So the speakers of the previous panel have set this momentum to all of us, to the following panels, and the last statements by the speakers mentioning the importance of memory, the importance of disseminating information, mentioning how one component of justice does not ensure accountability in the traditional justice system. It has to be a complex approach. The right to the truth is actually ensured not only through documentation, but also through justice, through pre-trial investigations, through court verdicts, that also ensures the right to the truth for victims and their family members in the Ukrainian society at large. All of these crucial statements we will elaborate on with our speakers right now. As you see, we have quite a comprehensive setup here with different representatives of the law enforcement sector. And I would love to begin by saying that when we first wanted to design this platform, we thought about the insane number of questions that could be discussed in the panel of justice and responsibility. Because people mentioned that the first pillar of transitional justice is justice and accountability, but very often our European colleagues mentioned the right to the truth as the first pillar, which is why we started with that on the first panel. However, let us all think about the fact that we have to concentrate today on a couple of aspects, which is why we chose these two crucial topics. So, 11 years after the beginning of the war, how is justice ensured for both, and justice for the victims, but also accountability for perpetrators, right? Through the in absentia proceedings. And I hope we can also touch on the consequences of applying criminal legislation against potential collaborators or people accused of collaboration activities. There are a lot of benefits to the in absentia proceedings, in particular the fact that we have a huge number of criminal cases, criminal proceedings, more than 180,000 of those as of November. That's a number that was publicly mentioned, and that number only grows each day. So collecting these documents, collecting evidence, and waiting until we could physically bring an alleged perpetrator to Ukraine is not something worth doing, because for a lot of them, it will be impossible to find these individuals. So the system has to still continue working to make sure we avoid a collapse of the justice system at large. On the other hand, and this is something that was mentioned and acknowledged by the Supreme Court, and there are publications that acknowledge that as well, is we have to study the verdicts by the European Court of Human Rights on the articles of collaborationism, because some of the experts mentioned these cases as those that the cases of Ukrainian courts as those that could later be tried in the European Court of Human Rights. Of course, for the Ukrainian society, it is the issue of resources that Ukraine in 10 years could expend to pay compensation to the individuals that could potentially receive positive verdicts from the European Court of Human Rights. But this is an issue of the image of Ukraine as such. So I suggest our speakers to step away from concentrating on the procedural aspects of these two processes, right? So the in absentia trials and the collaboration trials, but instead to look at how the current justice system is resilient, on how the system can provide the stability and the sense of justice to victims and survivors, how likely it is that these cases and these verdicts will be retried in the European Court of Human Rights, and on how these hypothetical elements of justice would impact our resilience and our ability to rebuild and restore after the end of the war. Which is why, Stanislav, I would like to start with you.
I understand that this is a question more of a philosophical nature, but let us digress from procedural aspects. To what extent does the current system provide for justice for suspects and victims? And how are you coping with such huge volumes? Thank you so much. Good afternoon. I represent the Department of War at the Office of Prosecutor General, and this basically frames my train of thought and the information that I would like to share with you. Since we're talking about international crimes, first and foremost, war crimes that are committed by the Russians. It is true. It was already mentioned a few times what the numbers are. Almost 200,000. I think it's 193,000 something war crimes that have been registered, and there are more proceedings because one proceeding can encompass a few such facts. But this trend demonstrates that next year we're probably going to have over 200,000 war crimes committed. Clearly, for all of us, both for the society, for the state, and various institutions, this poses a huge challenge. And countering war crimes the way we're doing now clearly is the product of how everything has been evolving since 2014 and what happened in 2022 all the way to the present day. What am I trying to get at? The system that is countering war crimes, talking about its resilience, I cannot say that, of course, I have no bias and no prejudice, but I do have certain confidence. The state actually did a lot of what we requested. We have specialization at the Prosecutor's General Office as well as pre-trial investigative bodies. We also have international support. We're collaborating with the civil society. So basically what the state could do in a proper way has already been done. Of course, you clearly can find areas for improvement, but we still get good ideas all the time. And you mentioned victims and survivors of war crimes a few years back at the Prosecutor General Office, and therefore we established the Special Coordination Center that is focused specifically on supporting victims and survivors. Basically, it comprises public officials who are accompanying the victims and survivors to walk this path with them and make it as simple as possible, because we all are adults. All of us who came across the criminal justice system, we all probably can agree about the fact that it's not that friendly. Even though people who are trying to do their best working with criminal cases still leaves its imprint on every person dealing with it. And that is why I believe that first and foremost, war-related infrastructure within the Prosecutor General Office basically, it allowed us to create the department that is trying to meet people's needs. And this is very important. Now, I'd like to emphasize one more thing. Here we're talking about in absentia rulings. It is directly connected to memorialization and the right for human rights. Without going into procedural details and subtleties, maybe we are gonna mention it later on, but if we select between doing nothing and investigating as much as possible, we are going for the latter. And Anton mentioned Bosnia's example today. I actually had a chance to visit it in the framework of a study visit and learn more about it. Let me put it that way. In about 2002-2003, when the so-called main tribunal for former Yugoslavia ended its work, all the cases that it dealt with, and they didn't cover all of them. I think there were around 200 people who were sentenced. And then the rest of the cases were transferred to the national bodies of the Yugoslavian states. And my colleagues from the prosecutor office can confirm. Imagine, in 7 years' time, because the war ended in 1995, some international institution transfers the cases of some criminal proceeding and say, well, guys, it's up to you now to investigate it. It's 7 years that passed, and if we take 1992, then it's going to be even 11 years later. So you can actually challenge in absentia, challenge a lot, but the alternative is just sitting down and waiting for a debate yet to come. Yeah, thank you, Stanislav. Yeah, I believe that many theorists and practitioners alike stick to the same position. Okay, now Mykola Mazur, Supreme Court. I have the same question to you. And what is your conclusion? How resilient will this system be after the war is over? Will it work? Or do you already see certain gaps to improve this system? Thank you for this question. Well, I'm gonna approach it from a different perspective. The reason for that is that I fully agree that all these crimes need to be investigated. And the problem with absentia is not that we cannot investigate. The problem starts popping up when we transfer to the court, where we do not have the accused person. And any international standards that were taken into account basically have to do with actually holding accountable the accused person, because you can investigate everything in absentia, whatever that you can think of. So what has happened was in absentia procedure during the court hearing. I looked at the register and I attempted to see how many sentences have been approved in accordance with this procedure over all the years. Well, maybe my search inquiry was not the best. That is why I cannot guarantee you that it is an exact information. But I think I found around 4,400 different results that mention the word special pretrial investigation. To be more precise, 4,200 of such rulings. But again, it was just an inquiry in a search engine, so maybe it's not an exact number. Now, speaking about years, you're well aware that this procedure was introduced in 2014. The first such rulings popped up in 2015, and there were a few of them. I cannot remember by heart how many. And then in the coming years, there were a few dozens until 2022. In 2022 onwards, the number of such in absentia sentences for the first time was over 100. Last year, there was 1,500. And this year alone, there was over 1,600. So we can already tell that annually, judicial system is generating thousands of such court rulings, well, hundreds at the very least. And among them, if we look at the statistics regarding war crimes, I managed to do some math to just double check it. And there were 125 rulings as of April 2022 in the register. And in absentia versus in person, I think 11% accounted for in person court trials when the person was present in the court, when the perpetrator was there. And over 80% are in absentia. So the first sentences after the full-scale invasion from May until September 2022 were mostly in-person rulings. Later on, the trend reversed. And starting fall 2022, the number of in-person rulings can be counted on the fingers on one hand. But on the other hand, the in absentia ones are coming in dozens and hundreds. I'm talking about this 4,200. Well, to be fair, I didn't check the category breakdown. But something tells me that the vast majority of these sentences and rulings have to do with collaboration, the treason, or something that has to do with this war, something that pertains to it. Why am I talking about it? For you to understand the statistics, because starting 2005, Ukraine has been among top 2, top 3, top 4 countries that have various rulings against versus Ukraine. Among all the countries that are members of the European Council of Europe. And we are always among the top countries in this statistics. And that leaves much to be desired. My time is coming up, but I want to share so much more stuff with you. So I'll try to be as brief as possible. There are already examples in the European Court that demonstrate what risks we might come across. A classical case is Senator versus Croatia. Person was sentenced in absentia in 1999 for the crime that was committed in 1991. And the sentence came into power in 2009, 18 years after it was committed, 10 years after the sentence was made. Savadang asked to renew the proceeding. And he never even came to Croatia since then. He was first in the occupied territory, then he lived in Serbia, and he asked to renew the hearing. He said that he has a right to do that, and the national courts refused him. In 2015, 24 years after the allegedly committed crime, 14 years after it, the European Court said that Article 6 of the Convention was violated, and he was compensated 6,500 euro of the moral damage. The person who never served in prison managed to obtain a compensation of 6,500 euros. And this is a red flag. This is a red flag that we probably can apply to the number of sentences in absentia that we have in Ukraine and the ones that are yet to come. Therefore, I'm not saying that these in absentia sentences that we need to forget about them, discard them whatsoever. No, what I'm trying to get across is that we simply have to make the procedure such so that the European Court for Human Rights will not challenge it, so that people that we are sentencing will actually serve their sentence rather than receive compensation from Ukraine dozens of years later. Well, I could have elaborated on it in more detail, but unfortunately, the time is up. Thank you, Mykola. I think we might have time later. Maybe there will be some questions from the audience that are related to that. And because we have so many legal professionals in the group, and you basically are segueing to the next person. The person who knows everything from A to Z working with the European Court for Human Rights. You know, the so-called postponed justice from the position of the victims and from the position of allegedly suspected. So it might be challenged by the European Court for Human Rights, and there is the probability that Ukraine will have to probably pay some compensations. Or are we sticking to the standards of fair justice and we can sit back and relax? Look, it doesn't matter what I think about it. The European Court has their perspective and their considerations regarding that. And they have very clearly said that in absentia sentences, without a possibility to later, once again, hear the case, is considered to be improper justice. And the colleague has just mentioned a lot about the Senator ruling. And there is also Saidovic versus Italy, and it was the decision ruled by the bigger chamber, and the European Court has already established the principle of what it should look like. So when a person is sentenced in absentia, cannot later go through yet again one another court procedure in case it wasn't stated that they refute their right to come to court and defend themselves, or that intended to avoid justice. Then it is considered to be the violation of Article 6 of Convention. What is it going to look like in the future? Well, you understand more or less what is the number of such rulings. We have a special procedure to review such rulings by the Grand Chamber of the Court, but it requires certain resources. So the Grand Chamber will be dealing with these cases, and then they will either make their decision or they will return it back to us so that we hear it once again. And provided the practice against Ukraine, all the cases that are naturally, for example, the Lahverdan, that will be tried in court. Now the position of the European Court is such that when reviewing them, every possibility should be given for new court hearing. And providing all of the previous example that in absentia cases should be reviewed when it comes to the facts and when it comes to their rights, well, it should be done in the court of the first instance. And now let us look at the consequences. The thousands of cases that have been transferred back to the court of the first instance, then the court of appeal, then court of cassation. We can also have special legislation that can be developed. For example, I do not understand why this legislation is still not in place, why no one has still drafted it. Another thing, without legislation, it is also possible in theory, but it depends on practice of the Supreme Court. For example, it is possible to assume that the Supreme Court would look at the possibility to look at the person's motion to challenge it at the Court of Appeal or Court of Cassation. When the court is dealing with them, that case will again be returned to the Court of First Instance. But in general, we understand this overall situation. And to sum it up, maybe I took a little bit too much of your time, but I would like to quote the Criminal Procedure Code of Ukraine, Article 602. Ukraine doesn't put in action court rulings of international courts that were made in absentia, i.e., without person's presence during the court trial, aside from when the person was provided the copy of the court ruling and could appeal that. So basically, Ukraine is the one refusing to stick to the sentences made in absentia in other courts. So how do we have the right to demand the same for them to actually approve of the in absentia sentences if we do not have this procedure for reconsidering that? Mihailo, thank you. It is clear that, same as many other countries who also ended up in the situation of mass violation of human rights, international humanitarian law, we need to make the system work. We cannot just keep piling up these cases, but at the same time, we need to stick to the justice of a fair judiciary. And there is a high risk, high chance that the case will be returned following the decision of the Supreme Court, which is also a safeguard, which is a very good filter to double-check whether the decision made in the court of first instance was actually justified. But then on the other hand, there is a risk that the European Court for Human Rights also might discard that, and international tribunals might not be able to cope with so many cases, and then they might transfer it onto our local courts. Okay, now I suggest we go one step higher. The level of international advocacy. Mykola, a question to you. So this system of justice, it works, yes, there are certain risks, there are certain benefits. It works because it simply has to work. So the impact of these possible risks, and this is something that both experts and practitioners are talking about, international advocacy of our interests, creating this future specialized tribunal. What is your perspective, since you are kind of a bridge between national and this supranational level? How does it affect our interests?
Thank you. In a way, we export Ukrainian standards and Ukrainian realia to the international audience because, as you probably are aware of, the Special Tribunal on the crime of aggression against Ukraine that we are currently in the process of establishing, that we have gotten approval for the key pillars for Ukraine, has signed a bilateral agreement with the Council of Europe on the establishment of the Special Tribunal. It is available in the Verkhovna Rada Narodov episode together with the statute, and we are currently going through negotiations on the extended agreement that would permit for the funding for the specialized tribunal. So, when discussing this special tribunal, one of the key issues outside of the issue of immunity as leaders of the government was actually the issue of in absentia trials. And we understood quite clearly that establishing a special tribunal that would just nominally exist on paper, that would stop investigating using the case law of ICC, the Coney confirmation of charges. So after the confirmation of charges, the tribunal would just stop. That was not in the interest of the justice system. It was not an easy decision. It was not an easy discussion. However, we were able to convince our partners that the special tribunal has to be able to try perpetrators in absentia. It is reflected currently in Article 28 of the Special Tribunal. You can look it up right now on the Verkhovna Rada website. Specifically, it mentions that the Special Tribunal can carry out in absentia proceedings if the accused is absent, in the case if, after the approval of the indictment, the accused does not show up in front of the tribunal, if he or she refused to exercise their right to be present, or if all the necessary measures were taken to ensure the presence of the accused, and it is in the interest of the justice. The second procedural guarantee is that if the hearing is taking place in absentia, the special tribunal ensures informing the accused either by sending a summon or either through using media outlets, informing the accused about the indictments, about the time and place of the court hearing, the consequences of not showing up to the hearing, and the second element of that, the accused should either choose a defender, a defense counsel, or if they refuse, the defense counsel will be appointed by the specialized department for defense in the special tribunal. And the third procedural guarantee is that a verdict is carried out in absentia, the individual has the right for their case to be retried if they show up in front of the international tribunal or any other follow-up legal mechanism, except for the cases when they refuse. I'm sorry, you asked for us to not go into detail for the procedural aspects. However, I did. This became a testament to our willingness to continue to serve justice, even though there were countries that were quite opposed to that. But we brought up the case law of the International Court of Justice, of the ECHR, that has considered previously in absentia cases. Why do we need to try these cases in absentia? Because the justice in the context of the international tribunal is not only about the individual accountability of those specific perpetrators, organizers of the crime of aggression. All of us, I think, understand that it is very unlikely that we'll see Putin in Hague one day. But does that mean that we should stop our work? No. The special tribunal for us is about legally establishing the fact of aggression. This is something that we lacked since 2014, because the resolution of the UN General Assembly is not enough. Even today, people tell us, well, it was only adopted in 2022. That means the aggression didn't happen since 2014, but it only happened since 2022, which is something that is being mentioned quite a lot in the context of the damage registry, where they want to impose this artificial limitation of not allowing requests since 2014 to be submitted to the Register of Damages. We want to make sure that there is a legal foundation to tie all of these individuals to committing the crime of aggression, to having these crime of aggression be legalized somewhere will become a strong foundation for our follow-up legal and diplomatic work. And so it is so crucial for us that we will not give it up, regardless of what is being said on Twitter. We are not planning to negotiate at any peace negotiations. There are clear instructions given to not discuss justice issues in the context of current peace negotiations. It's not just an issue for us that, oh, well, you give up on the special tribunal and we will agree to not occupy Zaporizhia. No, it is the issue of long-term consequences of the end of this war. If the Russian Federation, as a country who's consciously destroying the entire international law system, the entire international geopolitical framework, if Russia enjoys impunity, it will be a signal for all other nations that they can do that. And there is a clear calculation according to game theory. Crimea, Luhansk, Donetsk, then two more regions, then two more regions, and then everyone else sees that they can do that as well. Which is why most European partners understand that. Some of the others are still harder to convince, but we continue to try to do so. But it is also very important in the context of the first panel of memorialization, right? Outside of the security element and the geopolitical element, it is critically important to understand the reasons for why this war started. When I lecture at European universities, I ask them question, why did Russia attack Ukraine? And they often quote, oh, NATO expansion. Yeah, well, that's because the Russians have been pushing this narrative for decades. They have John Mersheimer type talking heads. But if we are able to, throughout the legal proceedings, prove why Russia began this war, why they've been preparing for this war since 2004, why they started it in 2014, then we'll have a clear conclusion. Why are Russians currently relying so heavily on the Nuremberg Tribunal verdict? Is because it justified their invasion of Poland in 1939. It's because it gave them this national myth and national legends, which is why the verdict of the International Tribunal is so important for us right now. Thank you, Mykola, for referring back to the first panel. This is something that I also wanted to mention because those things are inevitably intertwined, and justice is very much material. And it very much materializes for victims and witnesses. And we need to ensure procedural justice for the perpetrators, the alleged perpetrators, and to ensure historical justice as well. And it is important that we refer to the lessons learned by other nations that have survived war. And Anton also mentioned today that we have to allow for this certain distance, right? Not only in the scientific community, but in our organizations, we also evaluate how easy was it to achieve resilient and lasting peace by nations who have signed peace agreements under the pressure of international community, and that those peace accords or peace agreements were not maybe as effective. And we see that with the Balkans. We see Serbia rearing their ugly side, and there is a risk of conflict there. The same goes for Colombia. Even though the militarized formations were dispelled as the result of the peace accord, today they still have the illegal armed formations, and the war, they're on the brink of the war right now again, and they're seeing victims of that war today. So how does this system provide the foundations for resilient peace? Because sooner or later we will have to sign a peace agreement, a peace accord, or we'll see Russia capitulate. I don't know, we'll have to exit the state of war. Roman, let's take this notional crystal ball, look into the future, and see how well the systems that exist today is a national system that has partially impacted the establishment of the international justice mechanism for Ukraine. So how will we see the achievements of this system that is now currently building the blocks for lasting peace? Thank you for the question. I think that today, looking into the future by 10 years later is a really difficult thing to do. I'm not going to look at a crystal ball or anything. However, I do think that the issue itself is very important because it is something that we are being defeated by Russia in. Our actions and our decisions, they are very much situation-based. But Russia is able to plan more long-term. And this long-term planning they're able to afford is something where we cannot even achieve parity today. So I'm not going to look 10 years into the future right now. Let's at first try to push forward our event horizon at least slightly, and see that we are able to actually plan long term, just like Russia. Because from our leaders since 2014, we've heard multiple scenarios, plans, perspectives, but then the long term perspective destroyed it all. So, what does it mean? That means that we have to start with properly evaluating the situation and being able to plan better, because currently our skills do not match our requirements. And I would hate to see the issues be extrapolated onto the human rights system, the law enforcement system. It's easy to come up with scenarios and talk about plans. It's much harder to critically estimate where we are, what do we lack, and how could we be different. Because we've made mistakes, a lot of mistakes so far. And when we start to try to talk strategy, develop strategy, a plan, anything, I would start by critically looking at what has been done. What has been done wrong? Why weren't the previous plans implemented? How realistically have we approached these estimates in the past? I'm delighted by the fact that our audience here is quite young. And I think that this generational change is something that we desperately need. It is so important for us to push forward this planning horizon. And when you see young people in front of you, you understand that you can only talk about today and tomorrow. You have to think and talk about the day after tomorrow as well. In this sense, I think that regardless of the issue that we would mention here, it is imperative for us to try to look at that issue from a further perspective. It's important for us to take a step back, because we like to look at things with the eyes of the present, through the present point of view, because in a critical situation, people try to tackle the issues that are critical for them today, which is understandable, right? But strategic planning demands a drastically different approach. And so we have to adjust our lenses. We have to adjust the way we approach these processes. We have to change. A simple notion, right? In order to build long-term plans and implement those plans, we have to understand what do we have to have at hand for that implementation to take place. We fight a level of ideas, right? Let's find this magical, great idea that everyone will like. We will put it at the foundation of the plan and write a plan based off of it. Sure, fun, cool. Ideas are great. The world is built on ideas. However, ideas are never enough to start seriously planning and implementing those plans. We often get defeated because we don't establish proper procedures, proper steps. And the whole issue of in absentia trials, I think that my colleagues have illustrated this statement quite well. What procedural issues could actually jeopardize this great idea. And we all remember that in 2013, in 2015, everyone was trying to find out how could we potentially reach the perpetrators and accessible for Ukrainian justice. So let's implement in absentia trials. Sure, fun, cool. But now we see that from the procedural viewpoint, there's so many risks that back then no one paid attention to. People ignored because it was important to have a verdict today from today, but not have a verdict the day after tomorrow. Look at the whole story with collaboration crimes. In 2014, we didn't have any state policy. We weren't even ready to accept this as an issue. In 2022, we drew our conclusions. And so the logic that was applied is that people have to be afraid of the consequences, right? So cease any cooperation, avoid any cooperation with the occupiers because you are afraid of the consequences. And I think that for the first few months of the large-scale occupation of Ukrainian land, maybe that strategy was justified from the viewpoint of the national security, because we saw resilience, we saw people pushing back and opposing occupation, we saw less examples of the collaboration with occupier. But this is very much not a proactive approach. This is a reactive approach. And if we're talking about long-term occupation and life after long-term occupation, you cannot use this approach. It is obsolete. And now we understand that it has to be changed, but no one is ready to take on the responsibility to change that approach. And everyone knows it exists as an issue. But now, when we have to get back to planning for the day after tomorrow, we not only lack procedures, but we lack institutions. And if you are a country with weak institutions, there will be no one to implement your plans. If you don't have the stakeholder to take on charge of the process, then the process will fall through, despite of how great your ideas initially were. And of course, we lack resources. But if you have procedures, resources, institutions, and ideas, that's when we can sit together and build our plans. If one of these pillars is lacking, then we first should start by changing the situation we are in, because without having Lego pieces, you cannot build the Lego figure that you need to build, unfortunately, no matter how much you want it. And in the past, I've quite often held these international events related to the treatment of international organizations toward Ukrainian civilians in captivity on the occupied territories, but I stopped doing that. Why? Not because this issue has become less prevalent, but because Ukraine is doing a lot of that here. When this project, I want to get back home, right? When the people who were the citizens of Ukraine who were convicted for treason and then they were sent to Russia even though they disagreed with the verdicts, then talking about having a system in Russia where they take civilian hostages would be strange, because don't we have the same thing? And that would also be monitored by the office who is supposed to protect human rights in Ukraine. How does it even work? Because if that is so, then our strategic ideas fail because lack of resources, because lack of institutions, because lack of procedures. And against this backdrop, we are quite limited in looking at the day after tomorrow. But the areas in which we are successful, they're different, right? Because look at how the Ministry of Foreign Affairs was able to convert a very complicated topic on the tribunal on the crime of aggression. And it was an unachievable idea at the start. To establish an international tribunal for the crime of aggression wasn't something that seemed realistic. They had to compromise on a lot of things, right? But having resources, having institutions, having procedures, having good leadership, having great ideas, it all got converted into a working mechanism that allows us to look into the day after tomorrow. These processes have to be set up in a way we need, and that have to be intertwined and interrelated, because the previous panel, the right to the truth, the memorialization, this is something that we cannot avoid. This is something that we have to invest strategically into. But we are also currently fighting a war of narratives. And it is impossible to win this war of narratives if you're not relying on just procedures, on just verdicts, on the issue of accountability that alleviates the issue of legitimacy of certain narratives. You've probably saw that Russian Federation and the International Court of Justice has actually filed a suit on the violation of the Convention on the Prohibition of Genocide. This is a classic war of narratives. Ukraine has filed a suit talking about the crime that was obvious, right? Asking the court to recognize that there was no genocide in Donbas. But now, at the highest international court, we have this war of two narratives. So if it happens at the ICJ, can it not be happening everywhere else? No, it is happening everywhere else. So our ability to plan long term is the critical precondition for our survival, for our victory, regardless of what your personal job is for the future. Thank you.
Thank you, Roman. We started slightly later, so we have 5 more minutes for discussion and some questions from the audience. So please raise your hand, then we're going to give you a mic. Yes, please go ahead. Don't forget to introduce yourself before you ask your question. Hi, I'm also the fourth-year student from Ivan Franko National University of Lviv. In the context of the questions that were raised, I'd like to ask Mykola the following. There is a suggestion, a proposal, a concept of introducing the judges who will be specialized in international humanitarian law. Do you think it's going to be efficient? Will it help us optimize the resources and improve the quality of court rulings? You're also mentioning the ruling of the Court of International Human Rights. You're mentioning international humanitarian law. So can we use that as a mechanism to overcome all of the possible challenges? This is a very, very good question. Yes, we do need people who are going to specialize in it. For example, when I was a university student, we didn't learn a thing about international humanitarian law. We didn't even have such subject. This is a huge area of knowledge that you need to get the grasp of. For the verdicts to be of good quality, it is necessary to have people who focus on this specific area. But there is a practical problem that pertains to the number of proceedings. For example, The Hague, the Netherlands, have only one court that is dealing with international crimes. And that court has judges who focus on that specifically. But they work with 1 to 2 cases a year. In the meantime, we have to deal with thousands of cases a year. That is why it is very hard to find a solution for this problem, and it is necessary to introduce some specialization, but I doubt that it can only be done by one court. We need to look at multiple options. Any more questions, comments from the audience? Hi, Ivan Dudka, National Police, Chief Investigative Directorate. My question is the following. If you're planning to use in absentia procedure for these aspects, what is going to be the mechanism of searching them and detaining these people? What mechanism are you planning to rely on? And are you planning to also resort to Interpol? And if yes, then in what status? Is it going to be the status of the international tribunal or just as a member state? Wow, this is a complicated question. Probably we can cross out Interpol. At least for now, we're not considering that. It's not for me to explain what are the challenges of working with Interpol currently. Now, talking about searching and detaining these aspects. Of course, these are not the classical cross-border crimes. When there is some suspect who is staying somewhere abroad and hiding from the investigators. No. All of our, so to say, clients of the special tribunal were on the highest positions among the political and military leadership in the aggressor states. It's not only the Russian Federation, by the way. We're also talking about Belarus, North Korea, probably Iran as well. And the thing is that this mechanism for searching these people and detaining them is a very complex politically military challenge that unfortunately I cannot offer a solution for. First, we need to launch the special tribunal, and later on, as it starts its operation, we're going to see what are the capabilities of this tribunal. And clearly, the capabilities are going to depend on how many member states form part of it and agreements that this tribunal will conclude to cooperate with others. So basically, these cooperation agreements will result in the tribunal's capacity to intercept someone, detain someone, and bring them to The Hague. Okay? Coming? Thank you so much. This is a very interesting panel discussion. I have a question to Roman Romanov. I agree 100% that these things are very clearly connected. The court decisions, the right for memory. It is necessary that we have very solid foundation for memory when there are no questions to justice. If we make a comparison, for example, the ICTU, is the configuration similar? The country that used to be a union fell apart, collapsed, that had various religions, various groups, and the Serbs start feeling in a very imperialistic way. There are also other actors who start violating the norms of international law. And if we look recently when preparing for the event, I looked at what were the results. 61 decision about 161 individuals. Why do they matter? Because it is an icon cases, the role model cases, so to say. So now, looking back at that, understanding this cause and effect between the justice and right to truth, should we postpone it, make this right to truth secondary, or when developing the state strategy to pay more attention to this connection, not discard the right for truth and think about certain measures? Again, I don't want to, squeeze the response from you. But maybe you have some experience to share. Is there this kind of a connection, or maybe it's not even there in your opinion? Thank you. This is a very interesting question. I think that to a large extent you have a point when it comes to the fact that we can draw multiple parallels between disintegration of former Yugoslavia and Soviet Union collapse and in-depth conflicts that were caused by those collapses. But making conclusion based on Yugoslavian experience now and transposing it to Ukraine, I think that these two criteria, the practice of tribunal and work with memory, are not sufficient. We need to also focus that, it seems to me that Dayton agreements, to a large extent, had very negative impact on the things that pertained with goal setting and development of Bosnia as a country in the future. So, those agreements mention things that had to do with restricting sovereignty of the country and all that constitutional model. Well, I visited Sarajevo, and to be fair, I was shocked by what I saw. People are happy that after the siege, horrible war, religious cleansing, ethnical cleansing, which is not happening in our context, which already does not allow us to draw a clear parallel. People are restoring, recovering, but they kept saying, we never had this kind of segregation that we have now, when kindergarten schools in Bosnia were always used to be mixed. Now this model with this separated government, separated between various communities, prevents the countries from developing, because any agenda, any planning is restricted by the time when this community has key positions. And this is what I mentioned, that they cannot change it soon, and that very much restricts truth, narratives, and approaches, because all of that is very ad hoc. And it is institutionalized at the level of society, segregated kindergarten, segregated schools, something that never used to exist when Yugoslavia was in place. So this piece completely changed the fabric of society. That is why, provided that there are no proactive assimilation targeted policies, I think it lays the groundwork for more conflicts in the future. Therefore, it's very important for us to find the memory model that would not be replaying the risks of conflicts, the one that is not going to be based on hatred. And I think that this is what makes it challenging, creating this long-term memory policy while the conflict is ongoing. Because the first thing that happens is heroization, glorification of your heroes. And second is building unity by discarding everything that has to do with the enemy. And then language, religion, etc. So all of that forms the part of the paradigm. And for the nearest future, I don't think that is going to be a very good approach. So in this regard, I can tell that, building connection on what has been proven as a crime that is obvious evil is better than building some abstract memory policy without relying on these fundamental decisions that are right-based. Thank you. Thank you, Roman. I'd like to thank all the speakers. I'd like to thank our audience. Well, I think that our speakers today provided lots of exhaustive statements for the institutions that will be planning strategic and tactical frameworks of the National Human Rights Strategy and the future transitional justice roadmap. So thank you so much for all your opinions.